Hi, very good morning. This is a Supreme Court judgment, interesting judgment. Vanita Patnaik versus Nirmal Kanti Chakrabarti. It's a case under sexual harassment at workplace. Facts. I'll call Vanita Patnaik as VP and Nirmal Kanti Chakrabarti as NKC. VP was a faculty member of West Bengal University of Juridical Sciences. NKC was the Vice Chancellor. BP filed a sexual harassment complaint against NKC before the local committee. Sexual harassment happened in April 2023. Complaint was filed in December 23. Hence, local committee rejected the complaint, saying that it is time barred because the complaint has to be filed within 3 months. Delay continuation period is 3 months. So, totally 6 months. Within 6 months, she has not filed the complaint, hence, it was rejected. Then she filed a writ petition before the single bench of Calcutta High Court. Single bench of Calcutta High Court quashed the order of the local committee and directed re-hearing of the case. A writ appeal was filed by the NKC and before the division bench. The division bench allowed the writ appeal, that is, quashed the order of the single bench. In effect, it agreed that the complaint was filed after 6 months, so it cannot be entertained. So, VP filed a SLP before the Supreme Court against the division bench order. The question before the Supreme Court was whether High Court was justified in rejecting the complaint on the ground of limitation. Supreme Court perused the definition of sexual harassment and the circumstances which would amount to sexual harassment. Let us not get into details of what it said of that. An aggrieved woman has to make complaint within 3 months from the date of the incident. In case of series of incidents, then 3 months from the date of last incident, she has to file the complaint. Local committee can condone the delay up to a maximum period of 3 months. Supreme Court said, if the complaint is patently time barred, then the committee may reject the complaint even without calling the other party to participate in the proceedings. Then Supreme Court looked into the facts of the case, the complaint filed by the VP. The complaint filed by the VP said, I am not giving entire thing in detail, just a gist of what is there in the complaint. The complaint filed by the VP said that the NKC called her for a dinner in September 2019. NKC even touched her hand, that made her feel uncomfortable. In October 2019, again he called her for a dinner and asked for some sexual favors. He threatened her also. If you are not complying with my request, then I will do something. He threatened her. In October 2019, her promotion was put on hold by Executive Council. It's a separate council, but subsequently cleared. In April 2023, NKC called her for a trip to a resort. You come with me for a resort. NKC threatened again, if you don't accompany me, then you will suffer in your career. In August 2023, she was removed from her post as director by the Executive Council. Executive Council is separate, Vice Chancellor is separate. So that you must keep in mind. In the meantime, some complaints were received against the VP, that is the lady, from the faculty members. A one-man commission inquiry was conducted by the Principal Secretary. He was appointed to look into those complaints. The Executive Council, after looking into the allegations, removed her from the post of a director. One point which is very, very important to note here is Executive Council consisted of retired judges and some eminent members. Then this VP, that is that lady, made a sexual harassment and victimization complaint. Supreme Court, after noting down the facts, said The sexual harassment commenced in September 2019. That was the first time he proposed for a dinner, the Vice Chancellor. The last incident was April 2023, where the Vice Chancellor called her for a resort. Let us go for a resort. That is the last incident, April 2023. Thereafter, even in the complaint, there is no incidents of sexual harassment. So the lady was removed from the post of director during August 2023. Question was whether the subsequent event of removal of the lady from the post of director is in any way connected with sexual harassment, or will it amount to sexual harassment? If it is, then the person is punishable. Supreme Court noted that the removal was done based on a report of NFCG, I think National Federation for Corporate Governance. Supreme Court said this cannot be attributed to act of sexual harassment. This was a collective decision of Executive Council, because I already said the Executive Council consisted of judicial retired judges and some eminent members. So they collectively took a decision to remove her from the post of director. And it is not a unilateral decision by the Vice Chancellor. Action taken against the lady, the VP, was administrative in nature and does not create a gender-based hostile environment. To fall under sexual harassment, Supreme Court said there must be a direct link between the action complained and the overt act of sexual harassment. In this case, Supreme Court said there is no such direct link involved. Supreme Court, on a consideration of all the facts, held that the complaint is clearly time barred and hence it is liable to be dismissed. That is the conclusion made by the Supreme Court. But the interesting part is going to come only now. The last part of the judgment. Supreme Court said that, open quote, it is advisable to forgive the wrongdoer, but not forget the wrongdoing. The wrong which has been committed against the VP, that is the lady, may not be investigated on technical grounds, but must not be forgotten. It must be allowed to haunt, H-A-U-N-T, haunt the wrongdoer forever. That is continuously till his lifetime. Hence, Supreme Court ordered that this judgment should be made part of the resume of the Vice Chancellor, which shall be strictly ensured by him personally. So you make this judgment as part of your resume. That is the order given by Supreme Court. My comments. Sexual harassment must be happening everywhere. In most of the places, today's world, it is happening because the lot of things are available on the internet, everything, everywhere, and all movies, even dances, everything. It's all based on sexual attraction. It may be happening in courts, high places, offices, and in many places. Many cases may not come to light because of the social stigma attached to it. The ladies may not complain because anything attached with sexual harassment, they look at the lady. So they may not even disclose it. So many cases, I think in my view, it could be more than 75-80% of the cases may not come to light, maybe in more than 90%. Point number two, it can also be misused by ladies. That also you cannot, because recently one case happened in Tamil Nadu where a teacher was complained about sexual harassment. Finally, the court found the teacher did not do it. Even small girls, school-going girls, they are making such allegations against the teacher for some reason, whatever be the reason, because the age is like that. I am not saying it is not happening in schools. One or two cases may be there. Secondly, it is not done in public. It is a private happening. Whether that really happened or not, only the girl or the lady and the person doing it will know. Otherwise, people may not know. The third point is, in many cases, there may not be enough proof also. Unless somebody sends a WhatsApp message or makes a call, or these people record the telephone conversation, then it is difficult to prove. If it is there, it is definitely punishable. They will get caught. The fourth point, which I am very concerned is in this case, I am bewildered by the judgment of the Supreme Court. Supreme Court says complaint itself is not entertainable because it crossed the limitation period. More than 6 months is over, so complaint is not entertainable. But Supreme Court says it gives a punishment that the judgment must be placed as part of the resume of the wrongdoer. That is, Supreme Court says the Vice Chancellor is a wrongdoer. There are two possibilities. One, the Vice Chancellor could have done it against the lady. Other is the lady might have got it because her dismissal or something. So she might have got infuriated, and then she might have filed a case against the Vice Chancellor. Both the possibilities are there at present. Even without an inquiry, even without an investigation, even without the local committee or somebody getting into the facts of the case, even without a trial, how the Supreme Court said that the Vice Chancellor is a wrongdoer, just based on the complaint. And the judgment must be, and punished him by saying that this judgment must be part of your resume. In my view, in my humble view, with greatest respect to the Supreme Court, it is hanging a person without inquiry. Supreme Court should have, even if it has condoned the delay and ordered inquiry, that's a different matter. For me, that's a small matter. But making it as part of your resume, this judgment, I'm saying that you are a wrongdoer. You are escaping from technical grounds, but it will haunt you for your life. That kind of a statement, I I think I'm not able to, with greatest respect to Supreme Court, I'm not able to agree to the views of the Supreme Court. Is it not the basic and fundamental principle of our courts, of our justice system, that it is better to let go criminals free than to punish an honest person? How did the Supreme Court come to the conclusion the Vice Chancellor is a wrongdoer? That is my question. With that, I will end. Thank you very much. Have a great day.